you all to, especially the committee members that have found the time today to come and be part of the discussion as well as decisions on how we're going to move forward with the Corrections Committee. Thanks to all of you all as well who are in attendance, as well as those who have agreed to come and share some ideas and perspective on where we are and where we're headed in Department of Corrections. But before the meeting before we do get started, I would like to say to, especially again, the committee members and to some of the others who are there, who are out in the audience with us today, thank you all for all that you have done. I know that this has been a extremely busy year for a lot of us. Some of us worked hard on a piece of legislation, on several pieces of legislation that we thought that the governor would sign into law, but he didn't. And there were some who are out there today that was even against the bill that we had. But what I would like to say today is that even though we have had our differences, even though we haven't always shared the same idea, I think from the discussions that we've had, from the meetings that we've had with the House, with the Senate, and with you all out there, I think I can say that at least we are in agreement to continue to work together. We have not been at each other as to how we would not make this work, but we have been joined together in how we will make this work going forward. And so I just want to thank you all for that, that we can still work together and try to make sure that we get not just good legislation, but the best legislation that we can possibly have to come out of this body, that the state of Mississippi can feel proud to say that we were able to do that. So thank you all for your continuing work with us as we continue to work with you all, so that hopefully in January or even before, we will have something good that again will pass through both chambers and find itself on the governor's desk again. So before we go down the list of those who are here today, I would ask my colleague from the House, Chairman Horan, would he like to have a few words as well? And from there, we would proceed with the agenda as printed. Thank you.
Thank you, Mr. Chairman. I want to welcome everyone here today. Appreciate everybody's attendance. I do think that we've plowed some of this ground before. Hopefully we can, for some of the members of the Senate that have not heard, weren't available at the hearing that the House put on. Some attended, some did not. I do think we're going to probably have to go back over some of the same territory that we went over in the House hearing. So hopefully some members can be patient. Chairman Barnett was there, and hopefully we won't do too much. But I think this is an important issue that we need to address going forward, something that we need to, as far as the parole eligibility and things of that nature, reentry, and hopefully we can, everybody that's going to present have some ideas on not only eligibility but also reentry and things of that nature that were part and parcel of the legislation that the governor vetoed. But we're going to have to work together, come to a conclusion. I want to remind everybody that the gentleman, Representative Ward from Alabama, when he testified at the House hearing, told us that the budget for corrections at Alabama was $590 million. Ours is roughly a little bit less than half of that. They have about 5,500 more inmates than we do, twice the budget. So if we can keep that in mind when we move forward next year as to things that we need to get done, that we're limited financially doing certain things for corrections. And we're going to have to be very frugal in our efforts to spend money. But with that, Chairman, I appreciate it. Appreciate you getting me down here. and inviting me to your hearing, and I appreciate it. Thank you very much.
Thank you, Mr. Chairman. All of the presenters who are on the agenda today, we would ask that you all would at least speak to this body from the podium so that everyone will have an opportunity to be heard. And the first on our list today is Mr. John Neal, who's the Association of the Chief of Police. We asked the Chief of Police, why you coming to the podium, Mr. Neal? I'll explain why. In several of our hearings that we've had already, you know that the law enforcement body that we invited were the Sheriff's Association. But we do recognize that police chiefs have basically the same job as the police, as the sheriffs do. And we wanted to hear from our police chiefs as well as to things that we could do that, or things that they may like to see happen as it relates to criminal justice. So, Mr. Neal, we appreciate you coming and to speak with us today, and you have the mic.
Thank you, Mr. Chairman. I appreciate the time before the committee here this afternoon. I'm John Neal. I'm the current president of the Mississippi Association of Chiefs of Police, 32-year law enforcement veteran. My entire tenure has been with the city of Ridgeland since January of 1989. This bill was brought to the attention of the chiefs pretty late in the session, and when we became aware of it, just a quick brief overview of it, we had some concerns with some of the language in there, not so much from the reentry part of it, but more along the lines of the percentages that were being outlined in the legislation as far as when inmates would be eligible for parole based off some of the crimes that were being committed. We certainly won't stick our heads in the sand and say that we don't need to work on the law enforcement side of it, but we also feel like there's a lot of work that needs to be done in the law enforcement and criminal justice arena, getting these people ready for reentry. There's things that need to be done to educate these inmates when they get back out that they are productive members of society and not recommitters of crime. One particular case that I would like to bring to the committee's attention is one that I was made aware of this past weekend, and it's got a personal touch to me. It didn't happen in Ridgeland, but it happened to a close family friend of mine, and she came home from church Sunday week ago, about 12 o'clock down in Simpson County, to encounter a house burglar inside of her house. She and her mother were there. They stopped by just to change clothes for just a brief minute. When she walked in, she found a window broken in her house, thought maybe one of her animals had done it, and as she was walking through the house, the violator was still in there. This is 12 o'clock on a Sunday afternoon. She retreated to her car, retrieved her weapon from her car while her mother kept an eye on the gentleman. They called 911 and reported that he was still inside the house. That she'd been broken into, he was still inside the house, which immediately prompted a quick response from the Simpson County Sheriff's Department. What I would like to do, if I could, is, without obviously disclosing the gentleman's name, I would like to go over just a little bit of his criminal history with some charges that he has faced over the past several years. His arrest record starts all the way back in 2010, motor vehicle theft, 2010, felony embezzlement, 2010, armed robbery, 2010, possession of controlled substance, 2011, armed robbery, 2012, contempt of court, 2013, house burglary, 2013, receiving stolen property, 2013, house burglary, 2013, motor vehicle traffic offenses, 2013, controlled substance violations, 2015, receiving stolen property, 2015, shoplifting, 2015, 2015 shoplifting, 2016 shoplifting, 2016 shoplifting, 2016 shoplifting, 2019 controlled substance violation, 2019 controlled substance violation, 2019 aggravated assault. This situation could have gone one of about three ways. She and her mother attacked, sexually assaulted, and left for dead. Second one, this lady who encountered him could have shot him under the Castle Doctrine. Or number three, the way that it did. She held him at bay until law enforcement got there. We've got to do a better job of making sure that these people are not the ones out there on the street, because we hear far too often, and we see far too often in the criminal justice arena where repeat offenders are out of prison and recommitting offenses. This gentleman certainly deserved a chance, but he deserved it back in 2010, 2011. And law enforcement has got to protect our citizens and our residents from these types of violators. And that's what we want to come to the table with, is ways that when you talk about reentry of somebody back into society, that we're addressing getting these people help so we don't have these types of offenders out on the street recommitting. He needs a job. He needs to be a productive member of society. He does not need to belong in prison because he recommitted. When he does recommit, then we need the processes in place that are going to deal with him. Mr. Chairman, I certainly applaud y'all for tackling this. We in the law enforcement arena are interested in criminal justice reform, and we want to do something with you to try to make this a much better process. So with that, give it my time.
I do have one question.
Yes, sir.
The gentleman that you referenced, or the individual, I don't know if it was male or female, but the individual that you referenced, how much of their, did they serve any time with the Department of Corrections?
Yes, sir. He's currently out on parole.
Currently out on parole. Do you know how much time?
At the time of this offense, yes, sir.
At the time of this offense, he was out on parole?
Yes, sir.
Do you know how much time that this individual had served?
That I don't know.
Thank you. Is there any other questions by the committee, by any of the committee members?
I'll ask. Yes, sir. I'm just trying to, and this is not falling on deaf ears. I mean, we all hear these type of stories, but as an association, what answers, what do y'all suggest that the solution be for our problem here between budget, problems with inside the facilities because there's no pro eligibility for 5% of our inmate population? What is it that the association can provide to this committee and the House committee as a solution? And I understand you gave an example, and I'm sure there's success stories you could also provide to the committee, those individuals that straighten their lives out. What is the association, you said you had some concerns about the percentages that came out in 21-23. What solutions do y'all propose as an alternative to what 21-23 and 1377 put before the governor?
Well, just, I guess the short answer would be more along the lines of some earned release versus just a blanket coverage. Once you serve a certain percentage of your time that you're eligible to go before the parole board. And I understand the budget constraints that our Department of Corrections is under, just like most governmental agencies are. And what we would like to work toward is more earned release, to where once that person is incarcerated, that there is a plan that's put into place that
Well, let me ask you this. How do you propose that Department of Corrections could implement such a plan if an individual has no hope of a parole date. What I mean by that is if someone gets right under the current scheme that we have, that if you're convicted after 1995 for any violent offense, you have no parole date. And I don't know if the individual you're talking about is paroled on nonviolent. I didn't hear that he had a violent offense in his history, but I assumed that he was out on parole on a nonviolent offense. How do you propose that MDOC program somebody? Let's say he's got a 4-year sentence for being accessory to an armed robbery where he's got to do 4 years day for day. How do you propose, or how does the association propose that we program those individuals that don't have a parole date? Because no different than any other individual for earned release, you got to have some programming, some mechanism by which you say, these individuals have been successful in this program, therefore they ought to be released on parole. Without that programming and without that incentive, how do the association, this is not a question I haven't asked a lot of other people that stand at that podium and others, that I haven't gotten an answer to the question yet. How do y'all propose that we do it any other way than giving them a percentage-based incentive for early release?
And we're not opposed to the percentage base. We're just a little concerned with the low percentage,
Let's say
be it
that-
down to like 25% of that sentence.
The 25% under 2123 was from nonviolent offenders. You would agree with me that there's a number of people that are in prison that your police department's probably put in on nonviolent offenses that are violent people. You would agree with me to that, right?
Absolutely.
And you would agree with me there are certain people that are in there on violent offenses that aren't necessarily violent people, correct?
Correct.
So do you propose that we blend the percentages in nonviolent with violent from 25 to 50, depending on their history of prior bad acts or prior convictions, or if you're a second-time offender, you can't get paroled until you're 35% for a nonviolent offense? Or do you have any idea what you propose that we have other than the 25, 50% thresholds? Because we're open to any suggestions that the association could provide us, or the Sheriff's Association, Prosecutors Association. Anyone wants to give us some options, but we haven't had one group throw a percentage at us yet that they say they don't like the 25-50, but we have had no options put on the table or no suggestions at this point in time.
And I'm afraid I'm not going to make your day any happier because I didn't bring any
I understand that.
any recommendations from the
You think y'all
Chiefs
would be
Association.
agreeable, or just, I'm not asking you to commit, that if within the violent offender categories, we were able to, instead of just making it 50, go to 40 to 65 to 70, depending on the type of crime. Would you look at those figures, because there's some violent offenders that, being an ex-prosecutor myself and talking to prosecutors, they feel like they ought to be given a chance of earlier release than some of the nonviolent offenders that they deal with. Some of the people that you're just talking about that are constantly coming back into the system, creating problems, that automatically getting 25%, regardless, as long as it's not a violent offense, they're constantly getting their 25% if they're not habitual criminals. You think that's something that the Prosecutors Association would be agreeable to just look at, see if whether or not they could endorse that type of legislation?
I think we certainly need to, because not only does this apply to the crime or crimes that they're currently incarcerated for, but I think that their history comes into play as well, and also their behavior once they are incarcerated. I would like to believe that when they are sentenced, that they have some kind of idea that they will get that parole date at some point in time, and that they're able to see that on the horizon and start.
Don't have a problem with the parole eligibility as something they can work toward. It's just that the numbers being hard and fast at 25 and 50 seems to be your concern. Is that a fair statement?
Yes, sir, and that's based off the fact that I don't think that any inmate up there is identical to the one in the cell next to him, because
That's
criminal
correct.
histories come into play, and crimes that they committed to be incarcerated, and also what they've done once they've become an inmate, the type of inmate that they have model themselves to be. I think that certainly comes into play, because if we're doing a good job on the inside, getting these inmates ready to come back out into general population, I guess in the free world, then they're going to be much more receptive to being a good citizen and not going back behind bars. And that's what we're concerned with is are we as an association and the chiefs of police across the state, are we relaying our message in a way that when these people are released, that there's mechanisms in place that can help them?
Thank you.
Senator Simmons.
Thank you, Mr. Chairman. Mr. Neal, Chairman Barnett and Chairman Haran and Chairman Bain and also Chairman Wiggins, they've done a really good job of having these hearings since Senate Bill 2123 was vetoed. And I agree with Chairman Haran. We just have not been able to get a clear, I guess, answer to what the objections are and what are the proposed solutions. Are you opposed as an association to reduce to writing all of the problems that you all have as association with Senate Bill 2123, and in that same letter propose the recommendations or solutions to the chairman on how we can get the support of your association on moving criminal justice reform forward in Mississippi, considering the fact of our inmate population and the cost associated with an increase of our population?
Absolutely not. No, sir, we'd be more than happy to do that, and would certainly appreciate the opportunity to have our voices heard.
And thank you so much for all you do with the association. I guess my only other question is, you gave a real long, detailed example of an unfortunate situation of someone that was released. Would you like to share with the committee of a positive situation of someone who actually went in and actually came out being rehabilitated, that came back into your community, that you'd like to share with the committee?
Absolutely, yes, sir. Maybe not from the Department of Corrections end of it, but in my early years as a law enforcement officer in Ridgeland, we had a young gentleman that was about 16 years old, and for 2 solid years, he was a thorn in our side, and we just could not get him to do the right thing and be on the right track. Single mother household. He had a couple of other young siblings who looked up to him, but he would not straighten his ways out. This young gentleman, a week after his 18th birthday, decided it'd be a good idea to flee from law enforcement. We were able to capture him, and from that time he spent 6 months in the Madison County Jail, and within a month of his release, he had taken on a volunteer position as a youth counselor at one of our local churches there in Ridgeland, and spoke often about his encounters with law enforcement and his time being incarcerated and locked up, and how that's one place he never wanted to go back to, and he certainly changed his life around.
Thank you so much, Mr. Neal, and your involvement in helping turn that young man's life around.
Thank you, sir.
Thank you. I think Senator Samson Jackson.
Thank you, Mr. Chairman. Mr. Neal, on the person that you mentioned earlier in your presentation, do you blame the courts, or do you blame Department of Correction, or do you blame the legislature? Who do you blame for the situation of that young person?
Senator, I just blame the whole correction, or the whole criminal justice system. There's obviously been a flaw somewhere in that, either from his end and not wanting to change his life, whether or not it's the prosecution end of it on not putting good enough cases together that we're able to convict him on some of these violent charges, whether it's the judicial system for not imposing harsh enough penalties on him that kept him locked up longer, the correction side of it for maybe not giving him the skills that once he came back out that he had good job skills that he could go and market to somebody. I don't know enough about this individual's personal life history to answer that question, but I would certainly think that we all have a part in this gentleman's failure in life to this point. Can he be turned around? Absolutely he can. And I think it's up to us as people who are involved in this criminal justice reform process now to take cases such as his and remember these, and us to do whatever we can to try to make sure that these people are either fixed to where they're productive, or that we put mechanisms in place to where they can't harm society any more than they already have. What that answer is, I don't know, but I do think that we all have a part to play in this, and I'm certainly grateful that the Chiefs Association does now.
Thank you.
Thank you, Mr. Chairman. Thank you, Mr. Neal. A couple of things that you stated. First of all, the fact that you want to see people earn release, and I think Chairman Horan touched on that. We agree, and that's part of the spirit of 2123 is some mechanism. We may disagree on percentages. Well, let's hammer that out. But some mechanism that most everyone that's incarcerated has a target to try to hit, to be released. The case you gave us, I would reference as an outlier. I don't think there's anyone in this room that would say that the system has worked in this particular situation, because I heard you list armed robbery twice. I heard you list home burglary twice. Both of those are crimes of violence. Both of that'd be 4 sets of offenses that have no less than 3 years as a sentence if they're found guilty. So we don't know how he was convicted, pled, what was retired, but what I want to make sure we do, and I know you know, there are lobbyists in the room, you yourself to a great degree are put in that position. You're a communicator. We want to do a better job communicating with law enforcement, with the DA's office, of specifically what we're trying to accomplish. We also want to simplify it. We don't want to have to get an abacus out to figure out when somebody gets parole. We want to work with MDOC for time calculation. But if we can stay with the spirit of we're trying to help them have earned release, to me that's step 1. Step 2, because this guy is so deep into the system, he would be a big habitual under most any circumstance if he has been convicted on these priors and if he's served a year or greater on any of those violent offenses. But the drug courts, the intervention courts, we're trying to target, and this individual, he had a lot of drug charges as well. That may have been the start of where he went. But we want to also try to incorporate that, as well as I would like to see the RID program come back. What you basically described of the young man you dealt with is RID. It was a six-month, basically, intensive discipline program. It was housed at Leaksville, maybe. But would that be something you'd like to see? Because my prosecutors, I see, have a problem now with young people, 16, 17, 18 years old, who commit a crime of violence that used to they would use RID that now get thrown into the system. Are those some things that we could target that would maybe law enforcement would be in approval of?
Yes, sir. Absolutely. We're open to a multitude of different avenues in this. Something that the city of Ridgeland is doing through our courts right now, and actually prior to the court process, is we've got a diversion program set up there to where when our officers encounter people on the streets, we're doing everything we can to try to fix problems in their social life so they don't get dropped in the criminal justice system when they shouldn't be. If we've got the young mothers out there who are shoplifting baby formulas and diaper, and if we can encounter those people and get them the help that they need prior to entering the criminal justice system, that's what we need to do as a criminal justice platform in the state of Mississippi. I have not seen what the Department of Corrections case management plan looks like. That's something that certainly would interest the chiefs around the state, so we know that when these people are working toward parole and that parole date and them getting check boxes to see that they've met what the requirements are for the parole board, what those measures are. You know, I hate to admit it, but we just think that they get incarcerated and they get to a certain point in their sentence, they come before the board, and if they don't have negative marks on their history, then maybe they're eligible. I think that there is, and I'm sure that there is through 2133, that there's a plan that's in place for them to be built back into productive members once they're released. And that's something that the Chiefs Association is interested in learning more about.
Thank you, Mr. Neal. And one of the other things that we've tried to do is put an identification in their hand before they leave custody of MDOC, a driver's license, because again, if they're gainfully employed, they're less likely to be involved in some things they don't need to be, but I'm probably not going to be gainfully employed if I don't have good identification to start with or do not have mobility. But thank you for your appearance and your words today.
Thank you.
Thank you, Mr. Neal. If there's questions by this committee to Mr. Neal? Thank you for coming and sharing with us from the Chief of Police.
Thank you for the opportunity.
Next, we have Mr. Anthony Smith with the Mississippi Parole Board. And also, he has Mr. Pickett with him as well. So, Mr. Pickett, if we could have both of you all. And I see we have two other members as well from the parole board. So if you all would like to chime in at any time, then you all are welcome to do so.
Do we have a quorum of the parole board, Mr. Chairman?
Yeah, I think so. It's three of the, how many of them is it? It's five on.
I think that's
Yeah, we got a quorum.
Mr. Chairman, I would ask if we could let our chairman, Steve Pickett, speak on our behalf, at least initially. That'd be okay.
We thank you for the opportunity. It is a surprise this afternoon. We did not know, but we were happy to be invited and happy to answer any questions from the committee. You know, as the Senator Sparks spoke of, our number one challenge is to get folks ID. That is the number one issue that we see that is an impediment to reentry. All the members of the parole board, including the newest members, Jim Cooper and Tony Smith, appointed just 4 months ago. Betty Lou Jones from Meridian, the longest serving member, going on 12 years, maybe 14, I'm not sure. And Nehemiah Flowers, who is back at the store, keeping the shop open and answering phone calls right now. Any questions?
I do have a question or two from the parole, of the parole board, and one I think is that we have continued to heard the concern of, just like Mr. Neal had, is that, you know, why is it that some individuals who society thinks that should forever be incarcerated find themselves repeatedly getting paroled or back on the streets again when you have those individuals who, as Chairman Horan had talked about, may have done one thing and can never have the opportunity or the possibility of being paroled. Can you all just share with us how or what's the process of when these individuals are released, or is there something else that needs to happen that we're not seeing, or can you just help us to understand, you know, what's really going on there?
The lack of reentry programs obviously have a dramatic effect on the number of repeat parolee revocation hearings. That is the number one driver at the board of people coming back. We spend more time in a week on revocations than we do reviewing cases. I don't have the answer. I can say, as far as Chief Neal, I have the utmost respect for him and the association and understand their concerns. But in my notes, the most thing that stuck out in my mind was when he said fixed to where they can be productive. I don't know how we can fix folks to be productive, and we have scratched our head and tried to do it every day at the parole board. And, you know, there is no predictor, in particular the instance of the house burglary, you know, how we could predict that that was going to happen. We have to make a decision based on the information that we have in front of us on the case, and we do the best we can, and we work hard for y'all every day of the week. And I don't know what else to say about that.
Mr. Chairman, let me ask you, you know, we're going to plow a little new ground in some of the old ground that we plowed over the last 2 years, but tell me right now, in any given year, best your ability to recall the figures in front of you, and I know you've looked at them before, what percentage of those of your hearings are those individuals for revocation, for being revoked off of some type of supervision? What would that percentage be? Close as you can get.
On an average year, the board reviews 5,400 cases. Of those, 2,400 return. At least that's been the number for the last 2 years.
Now, based on those individuals that are returning back, what percentage of those are nonviolent offenders that have been released? Can you give me an estimate of what that number would be?
Violent offenders that are returned?
Nonviolent offenders. Of that number that you're looking at, 2,400, what percentage of those individuals are nonviolent offenders that y'all had previously paroled and come back? What percentage of that number of revocations are those individuals that are nonviolent versus violent offenders?
Well, the only cases that we see that are categorized as violent are those that are sentenced before 1995.
That's my point.
The answer to your question as far as those returning would be 1 in 100.
Right.
Because they're very rare that they're paroled, one, due to the nature of the violence of the crime. And, you know, the folks that we see over and over again are exactly, you know, the folks that the chief used as an example. How long do you get for shoplifting? And it's the biggest nuisance in the county. The store owner's mad at you. They go to church with you. They're going to call you at home at night and complain about the guy. And, you know, they're probably going to call the senators too and say, you know, something needs to be done about this guy.
And
But
those individuals, I assume, are the repeat offenders that we're making reference to, because since 1990, well, actually, we had a change in law, I think, in 2004. There's a gap in there, but nonetheless, since 1995, under the current status, violent offenders technically have no parole eligibility at this
That's
point.
correct.
So the only option for early release is through MDOC, correct? Through some
Yes,
type.
the
And-
earned release supervision program's the only way that, you know, anybody else is released other than parole.
And
or
there's a
they flat time their sentence.
There's a percentage of inmates that are getting that through MDOC with no reentry requirements at all, correct? What I mean is, if they give them earned release and give them 50% of their time, because statutorily they can do that, they're not programmed out, correct?
That's correct.
Okay. And at this point in time, y'all are not programming any violent offenders out at this point in time. Is that a fair statement? What I mean by programming, do y'all release?
There are several hundred people in a year's time that we parole with a GPS monitor because that's the extent of our authority. We can't put someone on house arrest and ground them, you know, to where they can't roam. GPS monitor is the only tool that we have other than the usual alcohol and drug treatment, checking in with the parole agent, you know, weekly or, you know, twice a month based upon their risk score.
Now, if we were to make some changes in the parole eligibility statute, similar to 2123, not saying those numbers, but what would the parole board's recommendation be globally for us to figure out what we're going to do with the reentry as far as programming? What do you see And what do the remainder of the board members see that the parole board needs to, if we're gonna broaden parole, we want it to be a success if at all possible. I mean, there's no reason to do it if it's not successful. So what do y'all see other than probably better drug and alcohol? I know that that's part of some of the situations that we've got to address to keep some of the repeat offenders coming back. Anything else regarding aging population, anything that you can think of that the committee needs to hear, what needs to be included in any expansion of parole eligibility?
During my 8 years on the parole board, I've been a supporter of geriatric parole, and we've had many conversations about it every session. There's a bill that's drawn up. If you're going to take people that you don't want to see come back and that are going to be the biggest cost savings to the agency, that's going to be the place to find them. They're also obviously the least likely, to come back for a revocation hearing. So, I mean, they're going to save money in the long run. Just to be real blunt, I mean, the biggest issue is how much are we spending on reentry programs? And when you parole someone that you know has a drug addiction and they're going back to the same community that they came from, that's where the investments have to start. And it's not just make these people eligible or make these people ineligible. It's a much bigger machine that has to be, looked at and overhauled.
Can you give the board, the committee members, the benefit of how many inmates we have now that are eligible for parole but don't have a place to go to? You have what that number
Today there's over 500 people still incarcerated.
that have passed their parole date that the taxpayers are taking care of that.
The one example that I cite at every public meeting is a veteran that was paroled in 2017 that's still there today. And there's over 500 people. I mean, you could reduce the overall population in one fell swoop by releasing these people into a reentry program. You have 180 beds, and we're trying to squeeze 18,000 people through this, hole, and it's just not working.
And I assume that what you're saying is that through the transitional housing provisions that we have in place that need to be funded, but some of them need some tweaking of language, that could eliminate some of that 500 individuals from being in custody. If they were placed on Medicaid or gotten out and had someone that would, had a location, either private or through contract services, that would take those individuals. It'd be
That's
cheaper
correct.
that way, would it not?
Yes.
All right, what percentage of your 1995 parolees that are violent offenders, the best of your, if you can give the committee the benefit, what percentage of those eligible violent offenders are making parole now that are pre-1995?
Less than 5%, and 20 of the 60 some odd people that have died in custody since the first of the year were parolee lifers that were denied.
Geriatric stuff, and as well as parole by this board.
Yes.
And I want to talk a little bit about where we are with some of those individuals that have costing us about $8 million a year, as I understand it, between $2 and $8 million, depending on which figure you use. Aging population. Do you feel like that we need to, the bill that we passed, the House that died in the Senate, that allowed the parole board to actually look at those individuals and determine whether or not they need to be considered for parole based on their age? Is the parole board in favor of that? I know you're not here to make policy, but do you think that we could address some of the financial problems that we're having if we were able to catch some of these inmates prior to the time they start accumulating all these medical costs, and just look at whether or not they should be given some type of parole.
Well, you know, as an old deputy sheriff in the law enforcement business, I can tell you bricks and mortar, medical, and personnel are the only places you've got to cut. So if you're looking to save money and reinvest in reentry, which, you know, that's the real core missing element in all this, then
And that's basically, the answer is yes, that we need to look at that as an option to doing those things as they start aging, and looking at the medical aspect as a basic cost to each inmate. Is that a fair statement?
yes.
Now, I want to, you know, we've had some folks that have testified prior to this hearing about the 25 and 50% and how that works. As we sit here today, the fact that what percentage of our prison population is not parole eligible, that has no parole date?
Of the 19,000, 14,000 something, 14, I think it's something like 14.6 the last time I looked at the number. But of course, the numbers change every day. We may have 18.9 today and 19.1 tomorrow. But roughly 60, you know, over 60% are not eligible. So, I mean, we're seeing the same 5,000 people a year.
Over and over.
And in my 8 years, we've never reduced the population overall more than 3. And that was back in, I think, you know, 15, where it went from, you know, 21 to what it is today. So.
And has it been your experience that the fact that MDOC is not programming inmates is, what I'm seeing as chairman of correction, is that you're not seeing a lot of the programming with the funds made available to MDOC, because a large percentage of those inmates that they would be programming are not parole eligible. Is that a fair statement?
Yes. I mean, the vast majority are not eligible. So, I mean,
Would it make sense to MDOC to program those individuals if they don't have a parole date? It doesn't make sense that they would do that, does it? There's no incentive for MDOC to program individuals, to give them programming so y'all could consider whether or not these individuals have corrected their behavior.
There may not be a reason to, but that's the whole purpose of,
Correct.
you know, I'm not trying to be sarcastic, but that's why we're calling it corrections. And if we're not correcting anything, we're not going to get anything but the same result again.
Thank you, Mr. Chairman.
The biggest thing that we see from the people that we parole is they go back to an example, you know, a place where there is no reentry court, no reentry programs, nothing that holds them accountable to, as we tell them, change your people, places, and things. They go right back to the same people, places, and things, and we expect a different outcome.
Thank you, Mr. Chairman.
Thank you. Is there any questions? You have a question?
Yes, ma'am, please. Betty Lou
Yes,
Jones.
thank you, Mr. Chairman. Go ahead, I'm sorry.
Excuse me, thank you. I'm Betty Lou Jones with the Parole Board, and what I would like to emphasize is that you heard the figures about the number of who are coming back, which is over half of the ones that we parole. Until we give the tools to our staff and the tools to the people that we have paroled, we're going to continue to see that happen. When you can't get an ID, a driver's license for the inmate who is leaving, the first thing that's going to happen is he or she is going to get a ticket for a driver's license, and if they're a parolee, they're going to come back to prison. That's just a fact. And until we correct that, we're treading water. And we see it time and time again. And when they can't get a job because they don't have an ID, because they can't get it from our system, the state of Mississippi's system, then they're having more opportunity to get in more trouble. When they can't get a job because they don't have an ID. When they can't get a driver's license because they don't have an ID. That's the first place we need to start, and each one of these parolees needs to be assigned a navigator so that they can help them. Now, I didn't invent these programs. I've been to meetings all over the country where states have been successful in working on these exact examples. If the state of Mississippi is really serious about saving lives, saving money, stopping crime, we've got to keep these people occupied and taking care of what they need to be. Not us taking care of them, but teaching them how to take care of it. They come to us with no skills. They come to us with no education. They come to us with no family support. And we have to start there in helping them to rebuild. There are ways for this to happen. It is being done in many states. And I encourage and beg the state of Mississippi and this corrections committee to do what is necessary to make changes in the lives of these parolees so that our lives in the state of Mississippi and the citizens of Mississippi can be safer and lead a better quality of life all over our state. I thank you for the opportunity to say this, and I want to encourage you to do what I know can be done with your innovative and creative ideas, and I will pledge to help you if I can. And so will the rest of our board, because we know what has to be done in order for things to change. Thank you.
Thank you. And I think Senator Sparks had a question. Did you want to ask that to Mrs. Pickett?
Yes, I'm kind of to the board, but Mr. Pickett in particular, and I think Chairman Horan had asked some of these questions on percentages. Once again, this goes to the people that are in the room, is the clarity that got confused toward the end with 2123. The parole percentage is high because the only people eligible for parole are basically nonviolent offenders. Is that a fair assessment?
That is the fact.
Okay. One of the biggest hurdles I felt like we had, particularly from the prosecutor side and from law enforcement, would be with retroactivity. Again, whatever percentages we end up, 25 and 50 is what was in the actual bill, but the commentary that I've heard over and over again from prosecutors particularly is we looked the victim in the eye, we told them they would serve a certain amount of time, and now you're going to make me go back to them and tell them that I didn't do that. And I hear that. That doesn't mean that we don't do anything, and it doesn't mean that we don't have a difficult path. But I guess my question to the four of you individually is, if you have someone who's coming up for parole, and it's an egregious case, you don't live in that local community, you didn't prosecute them, you didn't arrest them. If law enforcement, the district attorney's office, and the victim strenuously object to someone receiving parole, because again, 2123, and it got lost in translation, it only made people eligible. It didn't release anybody. It only gave them the ability to get in front of this board. But how are you going to take, if we're able to pass something that has retroactivity, a parole hearing where law enforcement, the prosecutors, and the victim show up and say, no, I was told they would serve this much time, I'm fearful, etc. I mean, that's the real concern I've heard from the DAs.
Well, since the passage of the bill back in 2014, the question of how much time are they going to serve is answered. Nothing moves a parole date. There is no MET time, there is no trustee time, nothing changes a parole date. So you know how much they're going to serve. It's going to be 25%. So
well, but what I'm saying is, if 2123 had been signed by the governor, it passed both houses, it would have made retroactive that a crime of violence, which was a day-for-day crime, such as armed robbery, would have been a 50% crime. That person would have come before the parole board that when they were sentenced, the DA had...
I'm sorry.
Welcome, Mr. Chairman.
What kind of ringtone was that?
But I do think that is ultimate, and we're going to hear from the DEAs, I think, but that's a question I've had the most concern, is a crime that at the time of sentencing, under, 585, that this person wasn't eligible. Now we make them eligible with 2123, you're going to see them. How are you going to factor in objection from DA, victim, law enforcement under that scenario?
the same way that we do today. If any sheriff, chief, district attorney, victim call our office, they have a right to community input. We set aside 1 day a week in the afternoon just for that. And if there's opposition, I don't know of any sheriff or chief that'll tell you that we paroled somebody that they called us and objected to. The fact of the matter is that you got a 95% denial rate on violent offenders and a 60% parole rate on nonviolent.
And that's, I think, would help us as we try to communicate on the next bill, is if it is retroactive, it's not a rubber stamp. That their voice is going to be heard, and you're telling me it's heard right now, and that's the way it would continue to be, because that's the feedback I've gotten. It's just been, that's been the concern, which I think, you know, we just want to make sure we got all the cards on the table this year.
Well, I could see no reason why you would expect any change other than a 95% denial rate on aggravated assault if we were seeing them. For those people that we see today, sentenced prior to 1995, that's what we're doing.
Because one other thing I think we did in 21-23 is we raised really the level of participation, because we went from right to be notified to right to be heard for the victim in a parole situation. So it was, you know, we tried to make sure that if we were going to make it retroactive and we were going to make violent crimes parole eligible, that we would give a voice to the victims along the way.
Respectfully, I would tell you, and of course I don't know exactly what, you know, how long my future will be on the board. We are awaiting nomination or renomination, and we'll find that out after the first of the year. But I can tell you that there is not much of a chance that you're going to see a whole lot of thousands of violent offenders released by this parole board. And subsequent to that, I can tell you that we got a real problem with, because I'm telling you right now, there's 500 people that are paroled that have no place to go. So we've got lots of, it's just a lot of moving parts to this thing. I mean, the population base, I mean, you understand, we could reduce the population today by 500 people if there was a place for them to go.
I do understand
I mean,
that.
I don't know how much, you know, how much more serious that could be. And those are, you know, those are people that are holding up beds, you know, where future violent offenders, you know, could replace them. But anyway, Betty Lou does a much better job of speaking than I do, so she makes her point a lot plainer.
Thank you, Mr. Pickett.
Thank you. I have a question for the parole board, and I think Chairman Wiggins had one after that. But about what Senator Sparks said, one thing that I've heard the sheriff say multiple times is that when we talk about parole, is that they don't feel like they are part of the process, or they feel like they have been left out because they haven't been notified that these individuals will be coming up for parole. Is there any type of communications between the parole board and those counties?
It's the Department of Corrections' responsibility to get the community input from the sheriff, the district attorney, and judge. And
Can you repeat that? I didn't hear you.
The Department of Corrections parole agent, probation agent, when they make recommendations, they take it, I mean, they're sent a questionnaire and given notice that they're being, you know, that they're being considered for parole. So the sheriffs, the judges, and the DAs all have opportunity. If the parole agent has asked, you know, for community input from them, we look at that recommendation, and that recommendation carries a lot of weight.
Thank you.
Hey, y'all. Thank you. Sorry, I've been out, and I didn't realize who was on, and I brought this topic brought up a this discussion brought up a topic. And Steve, I sent you a letter. Did you get my letter that encapsulates this? You know what I'm talking about?
About a specific inmate?
Yeah, about a specific parole that clearly, I guess you haven't gotten it yet. About the carjacking and the, No. All right, so last week I sent a letter. Here's what, I think this encapsulates what is being talked about. And believe me, y'all I know what your job is and all that, and I could sit here for an hour and talk about it, but I think we're getting to the bottom of what this 21-23 was. from my district attorney, I got sent the parole eligible list, the list of people that were granted parole. I talked to Tony, I think I talked to you about this. And the case, the guy pled to carjacking, which is a violent offense, and literally was sentenced to 10 years. Okay? He was granted parole, literally granted parole in less than 6 months, and put on the list that he was getting out of parole in 6 months on a minimum of a 10-year sentence. How does that, and so my letter was, how does that happen? Is that a technical glitch? Because based on the law that I know of, and this is why the DA was bringing it to my attention, that carjacking is a violent offense, which means it's a 50% time, which means at a minimum they had to serve 5 years, and they were granted parole back into the community in 6 months. And that's where the sheriffs and that's where the people get really upset.
You would have to give me the name and number to where I could verify this.
Okay?
But I'm 99% sure what you're describing is someone that was on parole, and they got a new sentence for carjacking, which is not eligible for parole.
Right.
He said he got 10 years.
Right.
We paroled him from the existing sentence to start serving the ineligible time.
No, now what was, I looked at what, no, they pled guilty, 9 months ago to carjacking.
Correct. So he's got a new sentence. So
Yes.
he's going to stop serving the current sentence.
Okay.
And we're going to parole him to serve the 10 years day for day for which he is not eligible. It's called the Keys sentence.
But he's out of prison.
Not going to be out if he's got a day for day carjacking.
Okay, well, let me say this. Okay, I think, because it could be in the communication that's going on, and I found, and a lot of this is communication, that's based on the list that gets sent out about who's been granted parole. And this person's been granted parole in this case. And so the anticipation is that person has been let out, back out onto the streets in 6 months. And you're saying that's not the case?
Absolutely.
Okay, well, that's why, if you'll look for the letter that I sent, because I gave you the name and all of that, because I think that encapsulates what is going on. And if that's the case, because the DAs and the law enforcement think they're out in the community back after 6 months on a carjacking that they got a 10-year sentence on.
Absolutely, Eric.
But you're saying that, based on how things work, that wouldn't happen from y'all's
If they have a new sentence, no, it will not happen. If you were sentenced to carjacking for 10 years and you're on parole right now for possession of, methamphetamine from, 2008, and we parole you, and you go out and get a carjacking charge, when you come back, we have to parole you to start serving the 10-year day for day. It's called the Keys.
Okay.
They have a new hold, a new sentence to serve.
Now, my understanding is this person wasn't on parole already, so it was just like a new charge. That's what I'm saying. It may be a technical glitch or something.
They wouldn't be eligible for parole for carjacking, period.
That's what I told the DA.
Had to do that, but Joel and the sheriff, there's not one sheriff in this state that's ever called our office that I've ever talked to that would parole someone, so.
And let me say that I think is part of the communication, because rightfully so, the DA contacted me, and that's why I wrote you the letter. But I think based on what we heard in the meetings that we had, the communication is a two-way street. And, I know everybody's busy, but on things like that, it would help if there was that line of communication between y'all and the sheriffs and law enforcement, which.
And you are absolutely correct. It has been many years since we've gone to the sheriff's conference, but there's not anybody that calls that office that's an elected official that does not have their phone call returned the same day.
Sure.
And many, many folks, including the ones at this table, have my cell phone.
Well,
So if you've got a question about an inmate, we'll respond immediately.
Yeah, it's a two-way street. So thank you, Steve.
Chairman, I want to make sure, that case file on that drive-by shooting, y'all wouldn't even see that case file for parole, would you?
No, sir, unless there is a huge, huge mistake What's going to happen is when we get that, when I get that letter and find the MDOC number, we're going to see that he was on parole. He's been charged with a new sentence. He's been sentenced on a new sentence. Now he's got 10 years to do. So he will be leaving custody. We are paroling him from the existing charge for which he was on parole to start serving the 10 years for carjacking. He will be released, you know, at 10 years, literally 10 years from the day of the sentence.
Under the current law. Unless, the only way he could get out, the only way he'd get out early if MDOC implemented MET time and he got out in 50% time. That's the only way. Y'all would, that's not
That is
parole.
correct, but he would never be eligible for parole. under the current
Parole.
statute.
There's no parole eligibility under the current law. Technically, I don't see how y'all would ever see that file. It'd ever pop up on your screen if there's not a parole date.
Correct, unless there's a change in the statutes. We
No
would never
different
see
than
that.
someone that catches a sexual battery conviction and they have a possession of cocaine and you parole them to that sexual battery. You discharge them off of parole, get them off your docket, and let them start serving their day for daytime. Is that a
Correct.
fair statement?
Correct. And we do the same thing, you know, for anyone that's on parole that's got a federal sentence. I mean, we're not, if they've got 5 years to go due, we're going to parole them off the existing sentence. Because, of course, we're only seeing them because they're already eligible. So they've done their 25%.
And assuming this individual that Chairman speaking about, I mean, if you look his number up and he's not supposed to be out on parole, what remedial action could you take at that time? Pick him back up?
Yes,
Put him back in?
yes.
You got a right to do that, right? All they have to do is call you, let you look into it, is what I'm saying. Figure out.
Yes.
You haven't received any of those calls about this particular individual, complaint from either the DA or the sheriffs or the Victims Assistance Coordinator or anybody on the coast about this inmate at all? You haven't heard?
I've not had a chance.
It's first
to
you've heard
review
of
the
it, I guess?
letter yet.
All right, thank you.
I'm sorry, I pulled up the letter. It does say that he was, so that you know, was previously convicted of malicious mischief in Harrison County and was sentenced on August 13, 2018. He was revoked and then had the carjacking consecutive to that. So based on what you're saying is he was released on parole on the paper,
To start
but never
serving.
got out into the
Correct.
community.
He won't leave.
Okay. Huh?
He won't be leaving. He'll be
Okay,
there
and
till-
that's,
till the day
if
for
that's
day
the
is
case,
gone.
which it sounds like, I think there is a miscommunication between what the prosecutors think of as being parole eligible and what actually happens. And when they look at the paperwork, they go, this guy's been granted parole. So that may be where we can help each other to try to understand that. Thank you very much.
Senator Simmons?
Thank you, Mr. Chairman. And Chairman Pickett, I just want to say to the committee and to the chairman that I know I'm a living witness that you called back the exact same day that we called you. So thank you so much for being responsive. But I just want to make sure this is stated again to be real clear. In Senate Bill 2123, we not only said that victims had a right to be notified, we said that victims had a right to be heard. And am I correct that you said that there's even without that change, which of course was vetoed by the governor, 95% is the denial rate for violent offenders? Did you say that?
Yes.
Okay.
I'd like to add one thing about the notification system. We do appreciate input from anybody. We have a mechanism in place that is sent out routinely to judges, law enforcement, and community, where they have the opportunity to respond to the parole board prior to the inmate coming up for parole and to give us advance notification about what we can look for as far as this inmate is concerned. Most of the time, none of those are returned. Most of the time, they send back no comment. Now, sometimes we get things like never parole. He doesn't deserve to be on the street. I mean, we could get comments like that, and we pay attention to that. But we can't pay attention to it unless we receive it.
Questions to this body? If not, thank you all for coming and sharing with us. things that we was not aware of from the parole board. Again, thank you all. And Steve, I'll make sure that the next time we keep you in the dark as well. Now we have, and I know she's been patiently waiting, Ms. Cassie Coleman, the district attorney from Meridian, Mississippi. And I just want this committee to know that this is probably one of the few people that I actually like fighting with. We have in the last month, I think, become good friends, and I would just want to say, Ms. Cassie, thank you for listening, and thank you for keeping an open mind in moving this forward. And I'm really appreciate that, the fact that there have been so many things that we have disagreed on, but the one thing that we have agreed on, and that is that the both of us would like to see even a better piece of legislation submitted to the governor in January, even better than 2123. So with that being said, thank you again for, like I said, for continuing to want to work with this body, make that happen. And no, I do not have that information that you asked for.
And Chairman Barnett, I want to return that thanks. I very much appreciate the opportunity to be here again today, and the same to Chairman Horman for the last committee hearing. I appreciate the opportunity to be heard. I think what Senator Wiggins said is we very much have some communication issues. There's also obviously a lot of distrust. And so I also appreciate not only you listening when I rant and listening when we're trying to find some common ground, but also giving me an opportunity to speak again here today. I don't want to belabor the points that are already said, but I think that both of you already know that I agree with much of what has already been shared today in this hearing, and that is that the problem is the reentry options and the reentry programs. And I was there when the gentleman from Alabama shared the budget, and there was a collective group of heart palpitations when we heard what it takes to make those programs work. And I understand that that's probably isn't a reality for us. But one of the things that I think the prosecutors have kind of gotten a bad rep for is that we're just against everything, and we want everybody to go to jail, and we want them to go there forever, and we never want them to get out. And I'm sure that Mr. Neal also understands that, because the chiefs and the sheriffs have also faced that.
But Cassie, I'm sorry, and I know you're going to, but that has been what's happened over the last couple years. As somebody who's worked with the prosecutors, it is always about no. And it is not coming, I appreciate you coming here, but you're correct. And I'll say it right here. We had that meeting, and that's what it was, because that's what we get as legislators. And so I think we're probably onto a new path, but that's what's going on. And, hopefully that won't continue, but we have issues that you're aware about that we have to do. And that's what we get is it's always no. It's always no.
I'm not sure which meeting you're referring to, Bryce, but I've spoken to these two gentlemen,
Right.
both Chairman Horan and Chairman Barnett.
I meant the meeting after 2123 that involved the sheriffs and Hal Kittrell.
She wasn't it.
I know she wasn't.
Okay, but I'm here today, and so I can't apologize
Got
for
you.
what they said or did, nor do I speak for the association. So let me be clear with that. I'm not president or legislative chair. I am simply a DA. I'm the DA from the 10th District, and I'm here with my experience and was asked to share what my thoughts were. I don't know what conversation you're referring to, but every conversation that I have had, I have both listened and offered alternatives, and I think these two gentlemen will speak to that.
And let me say, I think that's what needs to happen, but you're speaking for yourself, which is great. But when during legislation and during the session, we hear from the Prosecutors Association, and interestingly, what happens is we hear one thing from them, and we go back into our communities and hear different thing from different prosecutors, including the DAs.
Let me.
And I know Chairman Barnett has worked with you and talked to you, but the problem is you're here. It's not a problem. You're talking as a very respected DA, and that's great. But when it comes up here to do legislation and the Prosecutors Association is talking to us, we get one thing, and that's what we hear is the no, no, no. I see some heads being nodded. So I think it would help if the DAs across the state, and I've been in a DA's office, would get together and get on the same page when they communicate through the Prosecutors Association.
Well, with respect, if you would allow me to speak, then you would hear something other than no, no, no.
Okay.
I also think that the idea that you're going to get all DAs or all prosecutors to come to an agreement is about the same likelihood that I'm going to get all of you to come to an agreement. I have committed to both chairmen that we're going to meet in October. You're familiar that we meet every October, and I've asked actually for some data to try to take back to the prosecutors. I've heard a lot of you say, you know, what would you propose and what solution? And Bryce, I know that you as a former prosecutor understand the position. We don't often like to bid against ourselves, right? Plea negotiations or anything else. And so our initial answer in a lot of ways comes back to what you mentioned earlier, which is that certainty. When we speak with victims, we want to be able to tell them what the sentence is going to look like. And I'm sure, Bryce, you remember the days of, is it 85, 55, 75? And nobody wants that, neither a defendant or a defense attorney nor a prosecutor. So I think that one of the things that the concern from the prosecutors is how we get that certainty. And I hear Mr. Pickett, and I've known him a long time, even when he was at the sheriff's office, and he's saying, I don't expect that 95% to change. In other words, this was just an option for parole eligibility. And so the question that I pose is, then what are we doing it for? If we still expect 95% of the people to be rejected, then what are we really accomplishing? And that's the kind of the debate that we've been going back and forth. And for the prosecutors, I guess as a whole, I think that I can say that what we do see is the data, like you're saying, that's coming across the fax machines, and maybe there is an explanation, or even the people that show back up in our caseload that were not supposed to be parole eligible, but now I'm dealing with them. And that's an overall budget issue. They're not just looking at the budget for the Department of Corrections, we're looking at the budget to re-prosecute those people, and you're very aware of that. But I think that for us, you know, I heard Chief Neal talk about earned release, and I know we start, you know, MET and ERS and parole, but what we're looking for is an opportunity for a person to show that they are rehabilitated. He made the good point. It's called corrections for a reason, and we're trying to have correction. And one of the things that I think that you're getting this pushback from the prosecutors overall, and I know that you know at least 4 DAs fully supported 21-23 as it was, 4 out of 22.
That wasn't communicated to me or in the public.
It was publicly communicated by those DAs. You may not have seen it, but they did publicly
Well,
offer their
it
support.
wasn't loud enough if that was the case.
Again, I can't apologize for other people. I'm just here today, and the first time I'm speaking with you, am publicly saying that there were at least 4. So what we have to find is a group of people that can come together and agree on what we think is fair and what we think is effective and what we think will work. I also think the biggest issue is that we're not looking at what we want to accomplish. My conversations with Senator Barnett have been lively and at times probably feisty, but I think that when he and I talk, and the more we talk, we have a common goal of how we want to see people move forward. My local senator, we had a long conversation last year about what do we want that to look like and how do we want to shape that and form that. And what we want is for people to come out and not come back. You know that even as a prosecutor. I don't want to have to prosecute you again. I don't ever want to have to see you again unless it's on TV doing something good. 48% of the people that came into the Department of Corrections last year, 48% of the new admissions were either parole revocations, probation revocations, ERA, all of those, 48%, half of the people are coming back. So we're failing them. We're failing our communities, we're failing our law enforcement, we're failing all of them if we're not given those programs. Chairman Horan and I went round and round about this idea of when do we get the programming? Right now the statute says it's within a certain time of your parole eligibility date, right? In other words, you get in line for those programs based on your parole eligibility date. So if you're a person who got an 8-year sentence on an armed robbery, you don't have a parole eligibility date, so we're going to turn you back out on the streets with 0 programs ever. Y'all have the ability to change that. Make it a release date instead of a parole eligibility date. One of the things I've asked for, and I know he's getting it for me and he said he doesn't have it, is give me something to show my victims, to show my law enforcement, to show the fellow prosecutors. You've got a group of people right now that are parole eligible. They're being paroled at a rate of 71.5% according to the last task force report. 55% of them are being paroled within 30 days of their first eligibility date. That's according to the reports that we have available to us. What I've asked for is show us the numbers of RVRs, behavior issues, because the whole idea behind this, right, is we want to give them an incentive to behave better within, and we also want to give them a reason to take advantage of the opportunities to be better when they get out. That is what I'm being told are our two goals. It's not just about reducing the population. We know that. We know that didn't work from 585. We are 15% better than the predictions of what our population was going to look like if we passed 585. So we're doing better than we even anticipated, but what we are seeing is now we got 65% of the people that are violent. You don't really have a stick because they don't have something for you to take away from them if they don't have a parole eligibility date. And we kind of wonder why we have problems. Well, because the vast majority of the population is now violent, and they don't have that incentive. But show me what those numbers are for the people that do. Are those people less likely to get RVRs because they know that that parole eligibility date is going to somehow be in jeopardy? Because what we're seeing is it's not. And what we're hearing is that it's not. And that's from people that are released from incarceration, people that used to work within the jails and the systems, that there is no RVR, there is no result. And that is the concern, is that we're just releasing people, and we're only releasing them to have to re-prosecute them if 50% of them are coming back. And we're not investing the money in the programs. The truth is that today, we have fewer programs available today than we did when we passed 585. And then on top of that, you know, I keep hearing this plea for transitional housing, and we got 500 people, right, that we could release today if we had a place to put it. And I know that costs money, and I get that you're trying to squeeze blood from a turnip. But when we hear the success stories of, you know, even when we heard the gentleman from Alabama speak, we hear that you get what you pay for. I also think there are some other places that there is a true desire to change. And one of the things that we talked about at the last hearing that I want to bring before the prosecutors is some retroactive application of 585 to the people that are serving these habitual sentences. And what I mean by that is, you know, you could have people serving a 60-year cell case, you know, sentence as a little habitual, 60 years day for day, on a very small drug cell because you were enhanced. So you got the double penalty, or a firearm, it could be any of those. And today, that crime may only carry 16 years. Under the eligibility for them to petition for early parole, of the DAs I've spoken to, all of them say their judges are already granting that anyway. Mr. Pickett would never have to see them or deal with them, right? If you applied it retroactively, if that 60-year sentence today would be a 16-year sentence now, that's a huge difference that we can make, and I think that's part of what we see. But you do have this mix of the life habitual people, and that's one of the things I've asked for, is how many of those life habitual people are currently serving time for nonviolent versus violent, you know, so that we can look at the history. I don't think that anybody in this room is very far from what we want the ultimate goal. It's just that there's a lot of distrust, right? You're saying, no, 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 and we're saying, well, let's try to find a different way.
Well, I think, Cassie, that distrust, if there is, which I don't disagree, comes from that the legislature for 7 years has been trying to address this, and we keep getting our hand put up in front of our face by the prosecutors. And I'm saying that, and that's where the distrust comes in. And while I'm on it, where is it within in the DA's office that it says your job description is responsible for parole?
Where is it in your job description, sir? I mean, my job description is to be the person who advocates both for my law enforcement, for my victims, and for a safe community. Again, I understand that you have heard answers that you didn't like, but I have stood in this room and I've heard answers that I didn't like as well.
No, it's not that I'd heard answers that I didn't like. It's that I saw how the leader of the Prosecutors Association handled 2123 and what was told. And while we're talking about certainty on 585, there's a lot of uncertainty before 585, and with 585 there became more certainty, just like 97-3-2, the violent offenses. You would agree with that, right?
I think that was one of the purposes, yes.
Yeah, to create certainty in there, to create certainty in the system.
Right.
Okay. So 585 has had its pluses and all of that.
I'm sorry. You obviously only heard part of what I said. The idea of reducing the population, reducing the nonviolent population, that's specifically what I was referring to when I said 585 didn't work. I wasn't talking about every aspect of the bill, but what the prosecutors have done is we have gotten on board. If you look at the sentences for nonviolent offenses, the average length of sentences have all gone down. If you look at the incarceration rates, they've all gone down. If you look at the programming for drug court and things like that, those have gone up.
So let's talk about the distrust. I'm sorry to interrupt, but let's talk.
Bryce, hold on,
Mr.
hold on,
Chairman,
wait,
can I have this last question? The distrust comes from that, as was said in the meeting with the sheriffs and Hal Kittrell and them, was that this bill was going on since January. Not one prosecutor came and talked to us about that bill. And lo and behold, misinformation starts getting sent out to all the senators on the floor and the House members that is completely wrong. Okay, when there's been 6 months for the prosecutors to come to us and talk about it. That's where the distrust comes from. It's not in the policy, it's how you're operating. And that's where it comes from. And that's coming from an association standpoint.
Before you answer that, Ms. Cassidy, and to Chairman Wiggins, I share the same, I feel the same way you do. And I think I've let Ms. Cassie know that on more than one occasion. But today is the reason I think why she's here, and the reason why I invited her here is because she not only heard, and this is in both of us, but she not only heard what I had to say in my, I guess, unliking how all of this unfolded, but she was willing to go back and talk to that association and let them know how individuals like you and I felt about how it was handled. So, Ms. Cassie, I appreciate that, and that's been part of the conversation that we've had to get us to where we are today, and that's what I said earlier about she's one of the people that I guess I do like fighting with this, because we don't always agree on every phone call that we have, and I can assure you that every phone call is that we've shared has not been to where we have really felt good about it, but I think we understood each other and know where we are, and I've shared those same concerns with Ms. Cass, and she'll tell you that I'll let that be known on more than one occasion, that the way that the association, the way that the individuals that lobbied for them handled the whole 9 yards was very unprofessional. In my opinion, it made us look bad. It made us look like we didn't care, and a whole array of things. But where she is and where I am, I think that again that we've somehow pushed our feelings aside to try and make sure that Mississippi is going to get the best of what we have to offer going forward. So, Ms. Cassie, I just want to tell you again, thank you for coming. I'm sorry that I didn't fill my colleague in earlier on what has happened, but please don't take, and I'm asking you to understand how he felt, because I mean, you know that I felt the same way.
And if I may, Chairman Barnett and Chairman Wiggins, these two gentlemen didn't know me before this started. You've known me for a long time.
I respect you, yes, I do.
But your unprofessionalism right now has caused me to lose a lot of respect. I took a very similar, for a lack of a better, more appropriate word, butt chewing from the two of them the first time I spoke to them. And we are never going to always agree. But I'm back here for the third or fifth round, and I'm going to take it from you, but I'm going to respectfully and humbly ask you to do the same thing that I'm here today doing, which is to just stop and try to listen, because I have tolerated it even though I had no part in it, and I do understand your frustration, and I hope you will try to understand the prosecutor's frustration, but the tone, the disrespect, the words, that is part of why you may not hear from many of us, because that's the response that has historically been given when we have tried to approach.
Not by me.
And again, not by me, but I've had to hear about my colleagues, and so you have to hear the same. And I'm just saying, and I've said it to these two gentlemen, and I'm saying it humbly and respectfully, this kind of garbage and this kind of posturing and this kind of just rudeness isn't going to get us where we need to go, because I'm here. I might not be able to rally the other 21, but I'm hoping to get at least a majority to agree with something that we could submit. You may not love it, you might not agree with it, we're never all going to agree with it.
But you would agree.
But the constant interruptions, the refusal to listen, the outright refusal to deal with people because you had confrontations with them in the past is ridiculous, and it's childish. And I'm here to answer any of the questions that you have about what my concerns are as a prosecutor or suggestions, but this isn't getting us anywhere. So I am sorry if you feel that they were rude or disrespectful to you. I apologize on their behalf, and I hope that you will accept that apology and that we can bury those hatchets and please try to move forward to something that's going to not just benefit the people that are incarcerated, but the community that we're all elected to serve, because that's what makes it my business.
So now, if I may, thank you, and I do accept the apology that you had, but it is our job as the legislature to make these decisions. And ultimately, it is our job and to make the laws that address this. So that can be made with the prosecutors or without. And I will note that it passed 2 chambers. Conveniently, you got the governor to veto it, which is fine, okay? So it would behoove everybody, including victims, who, by the way, if you didn't know, I have gotten a couple victims awards, so I know what you do, okay? I've stood up for victims. It would behoove victims, the criminal justice system, and the corrections that we all work together, and I agree with that. I 100% agree with that, and I appreciate that you are here and have talked with Chairman Barnett, and he's right, and I may have get hot under the collar, but that happened. This was a big deal, and so I think you're right for us to try to move along and try to get there. But these things need to be said, and with all due respect, I don't think it's unprofessional. I think these things have to be discussed if we're going to get somewhere. Because 585, Mississippi has been a leader in criminal justice reform. Oklahoma, Texas, Georgia, Louisiana, and it seems to me like there's 1, maybe 2 groups that have stood in the way of that. And it's not the Republican legislators. So are we all going to work together, or are we going to continue to say no, no, no? I hope that we work together.
I'm here, still being as respectful as I can be, sir. And if you have a question, I'm happy to answer it.
Okay, yeah, what is it about, okay, what is your version of 2123? That's my question.
What is my version, like what changes would we propose?
Yes.
Okay, so as I was just mentioning, I know that there has been some conversation about this sliding scale, not just being 50%. Do we go back to 75%? One of the things that I shared with Chairman Horan is that we find some way to be able to look at the numbers. Let's make it research-based. One of the things that we discussed was the 4-year repealer.
You were rude about it when you told me that.
Maybe now people see why when conversations start this way. But the idea, I guess, for the prosecutors is, just like you brought up hearing from your DA on the...
Hold on, are you speaking for yourself, or are you speaking for the association?
I believe I clarified that when I started.
For
I'm
yourself.
speaking for myself.
Okay, so the idea for you is what?
Let her finish before she's in.
I want to know.
It's difficult to answer when you continue to interrupt. So I want to answer, but there's only so much, because I get a little hot under the collar too, and y'all might be able to see it. I bet my face is pretty red right now. You got the closest view. Bryce, I consider you a friend, a fellow prosecutor, and a colleague. But I went back and looked after your message about Texas and Louisiana and Oklahoma, and they all still heavily capped parole to violent offenders, between 80 and 85%. I believe that Texas and Louisiana almost none. One of the things that Oklahoma did do was the retroactive application on the drug crimes, and let, I think, 7,000 people out in one day. I'm not saying that I can get every prosecutor to agree with that, but I think that what we need to look for is, if we want to talk about the 95% are denied, then show the prosecutors the numbers of people that were parole eligible back then, because there is a time that aggravated assault was parole eligible. What number of those came before the parole board and were paroled? Because if it was 95%, then we might see the temperature go down. But when the DAs are getting the same kind of thing that you were trying to deal with earlier, you know, with that person, and maybe it's just that they don't understand the piece of paper they got from the parole board, but again, that's what we're all here for, is communication. What I have asked for is the data. I think there's a couple of different options. One, I think, is let's start somewhere closer to like the 85% than the 50%, because what the idea is that we're saying that we want to offer an incentive. So that's why I'm asking for the numbers of the people that are parole eligible. How do their RVRs compare? I don't think that's unreasonable. If you can say that the people that get that carrot in front of them behave 200% better than the people without the carrot, then we can go and we can have that conversation with law enforcement and with victims and with prosecutors. I also think that we need to carve out categories. These two gentlemen know where I stand on second-degree murder. I think all murder should be off the table for parole until we can see some change in the numbers. And that is partly because I have looked victims in the eye and I have told them. And I guess this part is the part that I believe you do understand, Chairman Wiggins, is that you know what the murder 2 was for the DA's offices. Because before we had a life, right? We either charged you with first-degree murder and you got life, or manslaughter, and even if we gave you the full 20 years, you got 10. And so you've had all these DAs take advantage of that middle ground of a...
You know who authored that? You know who authored it? Me. With the support of the Prosecutors Association. And that may be what you're saying. We need to work together.
If you would let me finish, yes, sir.
Okay.
But you seem to be unable to do that.
No, I just want the record to be clear.
You want the record to be you, it appears. I was just offering a compliment about how successful I believe that bill has been.
Okay.
And my point is, part of the reason it was successful was because of that certainty. And yes, that's the way that it was drafted, and that's the hope. I can look a victim in the face and say, no, we're not going to give him a life sentence, right? But this 20 years is day for day. All I've asked for from the beginning is let's take that off the table and then we'll talk about the other. Again, I speak as a DA. I can't say with the prosecutors as a whole, but I think that the research for what we're trying to accomplish, what do those incentives actually accomplish, and then whether we look at a sliding scale, I actually think that the things that Mr. Pickett brought up, you know, their RVRs and what's their past criminal history, those are things that they want to know when they're considering it. I've seen the forms that you're talking about when the probation officer brings them. I'm sure you did too when you were at the DA's office. I first would fill them out with every past crime and why I objected, and now it's usually just object or don't object. That's where we're at. But I think the reentry plans are the biggest reason that we're seeing so many people come back. I don't think anybody would disagree, and Chairman Horan has said this a lot of times, right? Somebody that has served a 40-year sentence on a murder is probably not going to get out and violate parole. Though that's not really the concern. But there is a dual concern there with being able to tell victims what sentence they're going to serve, and then at the same time trying to be able to control that population and offer incentives for people to want to do better while they're there. And so I think that there's a lot of data that we could look at. So whether that proposal is that we carve out certain crimes, in other words, think that you could probably lose a lot of resistance over the murder too. When everybody got clarification on 21-23 about the sex crimes, the resistance went down. The capital murder crimes, the resistance went down. And so I think that part of that is trying to be able to figure out what people can live with, what promises they've made. You brought that up earlier. You know, I got to be able to look these families in the face and say that I'm doing what I told them that I would do, because you've had these conversations. Chairman Horan's had these conversations with victims when we say, oh, the last people we're going to start paroling is sex offenders and murderers, right? They're going to be last on our list. And so those are the things that I think that, yes, there's been a lot of good come from the legislation that you have helped draft and that you have helped push from beginning to end, because you do have that background. But you also have, as does Chairman Horan, that experience of knowing looking at a victim and having to explain that, or talking with law enforcement when they come to us with that list and want to know why. I think that the ideas of being able to set what those standards are, when will you become, what will we look at, not just a percentage and a date, but what kind of programs do you need to complete and what type of reentry. The gentleman mentioned RID, and I'll say, I always thought RID was the best thing. I offered it a lot to young offenders when I was a young prosecutor. But then when RID was taken away, it was taken away because the numbers showed that the recidivism rate was much higher for people that had completed RID than had just been incarcerated. So how do we fix that so that we have a program that doesn't keep people there? I think that the numbers, the 50%, you're seeing 50% of the people that you parole come back. We're seeing 50% of the reentry is part of the concern. You know, we hear 5% on violent crimes. That's what we heard today with this testimony. But we have the task force report that says 71% of people. I understand you're saying, well, those are only nonviolent, because that's the only ones we're dealing with right now. But those are the numbers that I think make it very confusing. I'm certainly, if you've got specific questions, like with regards to the geriatric, I'm certainly open to answering those, but I think that being able to have the data and show is going to be the best way to try to carve out something that's truly workable, that we're releasing the people that we believe can truly safely reenter society and be productive.
Yes, I have a question. We've talked a lot today about individuals that have been paroled and those that have come back. But realistically, that's only a small amount of the people that can be paroled anyway.
I'm sorry, I didn't understand that.
I said today we've talked about individuals that have been paroled and those that have found their way back to our prison system. But again, realistically, that's only a small amount of people anyway. According to Mr. Pickett, we still have about 14,000 individuals that cannot be paroled or have no parole date. So my question is, where in translations did someone not see that the goal of the end goal of 21-23 was not just trying to target those that are being released and coming back, but that other 14,000 individuals that are still left over there at the end of the day, they need the same help, they need the same incentives as those others who are finding themselves in and out. And we're realizing that those individuals that are being released and coming back are your more problematic people than those who are still there and have no possibility. So where can we work together to make sure that those individuals, that we can help those individuals? Because that was the end goal of 21-23, but we don't want to talk about that.
No, sir, I understand what you're saying, and I guess that's what I'm saying. It's almost kind of like the chicken and the egg. You're saying that those 14,000 people need the possibility of being able to be paroled. One that I've heard from you several times and Chairman Horan is we need an incentive to help people behave better while they're incarcerated, right? In other words, I need something I can take away from you. That's the carrot. What I think the concern is that we look at the numbers and we're saying 48% of the people that came in last year came in after being either released on probation or released on parole. That's the total. It was ERS, house arrest, all revocations. So I think that the response isn't that we're not concerned.
I don't mean to interrupt you, but I want to ask you just real quickly. I'm not going to interrupt you again, I promise.
You're fine.
A number of those individuals, I think you'll find out, are basically revocations based on drug addiction, things of that nature, that are repeat offenders based on nonviolent acts and also new crimes that are drug related, whether it be burglary, things of that nature. A large percentage of that, which we are failing those individuals when they get out in the first place, do not get me wrong. But I think it's an unfair comparison to compare those individuals that are constantly repeating and use a figure at 48% or 77% or whatever, and not have an opportunity to look at the figures for all inmates that have received parole. Do you agree with me?
I do agree with you, Chairman, and in fact, that is some of the figures that I've asked Chairman Barnett to get for me. So I absolutely agree with you, and I think it would be helpful to know that information, and that's part of the data he was referencing.
Can I ask you just a couple of questions? And I want to make sure, we're trying to develop some policy here. Can you tell me what's fair about an individual that's convicted of capital murder, given the death sentence, and has a parole date now, as opposed to an individual that is convicted, is 2 years older than that individual, capital murder, doesn't have a parole date? Can you tell me what is fundamentally fair about that?
I can't tell you what's fair about it. I can tell you that one of my first experiences in the courtroom, what the judge told me is that the fair comes to Jackson in October. So I agree with you, but I think that for prosecutors and probably for law enforcement as well, it's not that we say it's fair that this person's treated differently than this person, but when this person pled, they knew what the rules were, and when this person pled, they knew what the rules were, or were convicted. Does that make sense? And so that offender, and you and I have talked about that, that offender knew what the rules were then, and the biggest concern that I personally as a prosecutor and the DAs that I've spoken with, it comes back to that second degree murder of making a commitment to a family that if we take this plea, we avoid the cost of trial and all that for the county. But as far as, we've had that since I started, the pre-95, the pre-2014, that was one of the suggestions I offered, was that we take that people from 95 to 2014 and we look at them differently. And I know that's not a suggestion you liked, but...
Well, I didn't have an opposition to that as long as there were going to be some concessions made where the prosecutors would come and say, we endorse this legislation. And to be quite honest, I never got that commitment from the Prosecutors Association. If we looked at 95 to 2014, would they come on board with endorsing the legislation? I never got that commitment.
Well, in all fairness,
Again, that was
by the
not
time
your
those
position.
conversations ensued, we were in the middle of COVID and there really wasn't an opportunity to meet. And that's what I've offered to do, is try to take those suggestions back.
Well,
But
let me ask you this, between the 2000, now, a lot of members here don't really understand because some of them weren't here. 585 legislation was not intended to be a no parole provision. That only came to be because the interpretation of the language, the enabling part of parole, according to the Department of Correction, the AG's office, was not placed in the bill. The intent of 585 was for, even though those individuals for second-degree murder were going to be placed in there for 30 years, they were going to still receive the 50% rule for parole. That was the bargain that was struck in 2014. It was not day for day. Not one prosecutor, no one that was leading the charge for the prosecutors was ever led to believe that the legislative intent was day for day after 2014, correct?
it's incorrect. I can tell you that the prosecutor standing before you is led to believe that. And again, we can debate 585, but without a doubt, the 2016 amendment, I believe, is what cleared it all, that no, the violent crimes were going to be eligible for parole at all. You and I discussed that a couple weeks ago, and I think whatever amendment that was when it came in 2016, it's what took it all away for all violent crimes.
Correct, and then we got involved with the sell of cocaine issue, and again, the prosecutors stood in the way of, and you did not, I didn't hear your name, but nonetheless, when the sell of cocaine language had to be corrected.
You're talking about on the amounts?
No, the eligibility sell of cocaine for a period of time, they lost eligibility until a lawsuit was filed with the AG's office, objected to, and the Supreme Court ruled that basically you couldn't take those parole dates away. But here's my question. Are you willing to look at the 95 to 2014 numbers as a prosecutor? I know you're not speaking for the association, as to making sliding scale eligibility for violent and nonviolent offenders.
I've said from the beginning, yes, if you can get us those numbers, I'm certainly willing, y'all saw that from last time, to try to dissect and make sense of the numbers, and certainly willing to try and present that. I can only speak for me at this point, but I think that that would be the most effective approach, is trying to see how those numbers stand, what the release would look like, and then again, how much success are we having with the people that are parole eligible? Because just being parole eligible, even attaining parole or, being released on probation isn't our end goal, right? Because if half of them are coming back, then we really haven't achieved anything, because our goal is that I parole you and I never see you again, right? You go on and you do your life. And so that, I think, is where the concern, Chairman Barnett, to answer your question about those 14,000 people, is, are we really doing them a service if we release them only to re-prosecute them? They're going to be serving that sentence, and then they're going to be serving the sentence that's on top of it. One of the things I did ask for, Chairman Horan, were those numbers. How many of those revocations were new crimes? I can only speak for my district, but I would say 95%, probably more like 97%, of the revocations are only based on new felonies. But I can't say that that's true for every district, and so those numbers would be very helpful in making that evaluation.
Ms. Cass, I hate to interrupt you, and I'm sure you had a lot more to say, but just for the sake of time, I think I would like to ask you at least one more question and then let you kind of wrap up what you had, and so that we have two others that are on to speak today, and we don't want to prolong. But can you, when you talk to your DAs in that organization there, when you all talk to us about the 50% or the 71% or whatever number that you give about those that keep revocating, can you all not make it clear that we're talking about a small percentage of the people that are in our prison population? Because when you, for an average person that didn't know any better, they would think that you was talking about 50% of the 18,000 people that are incarcerated, when we're only talking about maybe 50% of 4,000 people, and that's a difference.
Well, and I'm sorry, when I use the number of 48%, that is 48% of the total. So the total admissions into
That can't be correct, because if 14,
I'm not saying the total current population. I'm saying according to the MDOC 2019 annual report, the new people that were processed in the front door, 48% of the new people that walked in the door were from a revocation. And if you'll give me just 1 second, I can give you.
Oh, I understand what you're saying, but
So I'm not saying total population, but I mean, we do have to apply some logic that if 2019 was 48% and 2018 was around that same number, then we are seeing a lot of people of that whole. And some of them may have actually been paroled on a drug crime, like that gentleman who's now about to go in on a home burglary and become not eligible because we didn't get him the treatment or the programs that he needed. And so
I understand that, but what I'm saying is that if we're going to give those 50% or 48%, then can we also say that 48% of 3,000 or 4,000 people that was paroled, instead of when we're saying the total, when we're saying the number of people incarcerated, because that's not being all the way truthful with the public, because when you say population, to me, I'm thinking, okay, they said there's 18,000 people incarcerated, and so 50% of those people, 50%, if you don't say 50% of those people, but if you just said 50% was paroled and 50% came back, so I'm thinking that's half of the total population. Of the total population, when it's not half of the total population. So that can be.
And I think that's where, and I'll show you, I'll send you the numbers. I've got your email. The 48% that I'm giving you, if you look at the people in 2019 that came into MDOC, so that population of people, 48% of them were on revocations. Now, I don't know what the overall recidivism rate, I read somewhere 31% of all people. In other words, everybody that gets released, whether it's a flat time armed robbery sentence or nonviolent, I think it hovers around 31 to 34% total recidivism, meaning, 3 to 4 out of 10 come back total. That number that I'm giving you on the 48% is the total population that came into the Department of Corrections as inmates. Now, I'll ask for that number if we could get that number from the population as a whole. I'm not real sure what it would look like based on like the Keys ruling. In other words, that gentleman from the coast will not show that he's currently in on a parole revocation, if I understood you correctly. He'll actually show that he's currently incarcerated on that new carjacking. So I might not, you know what I mean? If you'll give me those numbers, I will crunch them, but I don't know if we can get a true sense of the entire population right now, how many came back as a result of parole or probation
I
revocation.
have one last question I'll let Senator Simmons ask, and then we'll let you finish, and so the other two can come. Would you also agree then, Ms. Cassie, that there are probably individuals who are within the Department of Corrections today who were sentenced when the three-strike law was really enforced, and we're talking about drug conviction, those type of things, who were sentenced to a life imprisonment for the sale of drugs or something, and you even kind of hinted to it earlier, but today that same individual, if it was a third time, would only get X amount of time. So would you be okay, or would you think that it would be something that we should work on, is to put some definite look back language in there that would help those individuals? Because I feel like there's a number of those individuals that are part of this 14,000 that Senator Horan always talks about, that has nothing out there to no parole. So would you agree that there's something that we need to do along those lines, and that would help reduce the prison population?
With only one minor correction, I don't believe, like, anybody that's serving a life sentence right now is because they're 83 habitual. So no matter what offense they committed on that third time, they would still be eligible for life. But I do believe that there are people that are essentially serving life sentences, like you and I discussed, like a 30-year day for day or a 60-year day for day. If I'm over 30, that's essentially a life sentence. And that's where I think the retroactive application of the 585 sentencing structures, so like if somebody that got 60 years day for day, little habitual, and it now only carries 16. So I think, and if they've already served 27, they would be eligible for release. So as to the 81 habituals, I think you probably, and that's one of the numbers that I ask you for, I think you might see a huge number of those people that were incarcerated under those numbers of the 81 habituals that probably could be eligible for release just by retroactively applying 585's sentencing structure.
So Cassie, you're against any consideration of the 83 habituals?
No, I'm not against any. I'm just saying that, like he said, that today if you were sentenced, it'd be different. And I'm saying that it wouldn't be different for the 83 habituals. It would only be different for 81 habituals today. Do you follow what I'm saying? In other words, right now as it stands today, it doesn't matter if I sell a little bit of drugs or a lot of drugs. If I'm 83 habitual and I'm tried and sentenced as 83 habitual, I get life. So that's what I meant. I think we should look at all of it. I think everything should be looked at. I just meant, I think that the only ones that would be changed just by retroactively applying are the 81 ones.
Are you in favor of any sex offender parole eligibility at all? That's a tough question as a politician, I know, but...
No, it's not, and I'll tell you, I hesitate because am I personally opposed to it? Yes, but Ms. Jones is very familiar with a case out of my district that very much of my constituents would be against me on that, on a man who I think MDOC has probably resuscitated at least 2 times during his time incarceration. And if he were serving a sentence for murder right now, y'all would probably see him released under the medical exemptions. So I personally am Right now, I'm willing to consider the research and the data if you will show me the people that are there. I would only ever favor it if we did something like the state of Texas did, where we have extra monitoring for the sex offenders, that not just GPS, but they do the polygraph monitoring, and they do a lot of additional monitoring to make sure that just because you're old doesn't mean you can't be a sex offender. But just my off-the-cuff answer is yes. But I do know that there are a lot of people out there that would say otherwise. And again, it's my goal to serve all of those constituents. But I think that we would have to be very, very cautious. And I know that you have some ideas about the exploitation, and I think that's a little different from what I'm talking about.
Thank you, Mr. Chairman, and District Attorney Cassie. What we have dealt with, as you have heard, is a lot of misinformation and a lot of disinformation as we go through this process. And just to kind of clarify what Chairman Barnett was saying, the 14,600 of the total 19,000 or so, give or take, population represents about 75% of the population that is not even eligible for parole. So whatever percentage, which you agree with me that you are giving about people that are coming back into the system, it cannot be that 14,600 because those people were not even out.
Well, but I mean, you do see people coming back on probation, right? Like, in other words, people can be released on parole and then go to probation. So I think that in addition to what you're calling, misinformation, it may be a complete lack of information. I can't answer those questions without those numbers. I am very, very eager to receive them and look at them. But I do think that just the example I heard here today is that you could have somebody that's now sitting there. He's in that 14,000, right? Because he looks like he came in on a new crime, but he was somebody that was out on parole. He got paroled from that original offense and now looks like he's serving just that carjacking offense. So I think we would really have to take a hard look.
We just, as we go through this process and as we all get along and as we all work together to try to get some sensible legislation, we just don't want the public being told by our district attorneys, who will be our partners in this process, that 50% of 19,000 people are getting out and coming right back into the system, because it's just not true. It's just not true. It's not true. It's like 10,000.
No, that's what I just said. I'm sorry. Let me clarify. I think the number of total recidivism is probably around 31 to 34% total. The 50% makes up the people who came into the Department of Correction. So in other words, there's obviously people that did go that route and that we never saw them again. So I think that number is more in that 30% range. But I also think that what I'm 100% expecting to hear from the prosecutors and victims is also, don't tell me that only 5% of them are going to get parole. I mean, because that was kind of the rub, it opens the door when the published information that we can put our greedy little hands on is 71.5%. So those are the numbers I really think we need to take a hard look at.
Thank you, Ms. Cassie. I'll give you a few minutes to if you need it, but Mr. Pickett, you had a word, because I really want to get these.
Give her back the time I took from her, please, seriously.
Reclaiming this time.
I want to clarify one portion of the 71.5, and I am delighted that somebody has asked about that number, because we've been sending the annual reports over to Peer and to others on the first of the year, and I've never been questioned about any of that. I want to point out publicly to the chiefs and the district attorneys that it's very important to know, and this committee too, 22% of the parolees are the house arrest docket. So just because it shows that someone was paroled does not mean that that was a violent offender that was incarcerated. So 1 in 5 that we look at every month is already at home. And that's something. As far as the number that she's talking about, 3,000 new people come back every year. She's absolutely correct. 50% of them are recidivism.
Chairman, can you?
And those would be numbers helpful so you're saying of that 71%, 22 of them were just released from a house arrest bracelet to parole?
They were never incarcerated.
That's what I'm
That's
saying.
correct.
They got
Yes,
their bracelet
yes,
taken off.
that is
So
correct.
again, I mean, those
So-
are numbers, we just simply don't have the.
Chairman, what percentage of those violations were technical violations? Can you give me that?
We send a high number of the revocations to the Technical Violation Center because it is our only tool for which we can get alcohol and drug treatment.
I guess.
So even though it's a short-term program, it's the only tool that we have to where we can know that they'll be given some type of a program.
What's your inmate population as we speak today?
I can't answer that question. It's somewhere around 18,900, I think. I haven't checked, but I do have another number for you, and that is on September the 1st, 24,641, 24641 were on supervision. So that's the number of people that's on parole and probation is 24,000.
Can you tell me basically how many probation officers you have that supervise at 24,000?
Beg your pardon?
How many officers do you have to manage that 24,000 on population?
I'm sorry, the parole agents do not work for the parole board.
I mean,
so I
but
do
the
not know the answer to that question.
Yeah, but how many agents do you know? Do you have that figure?
I do not have that
Okay,
figure.
thank you.
Ms. Cassie, one last thing, and I promise I'm gonna let you all go. And this to Mr. Pickett, since you're standing there as well. To Senator Wiggins, I'm sorry, to Chairman Wiggins' point earlier, that was basically our frustrations with everyone in regards to 2123, because there was information that was text and called into senators that had them believing, and even out in the public, that had them believing that all of these individuals who had been released and are coming back, and there ain't no, so that's what the problem is. It's just like what Mr. Pickett just said. There was a lot of information out there that if the DAs and everybody else wanted it, they could have gotten that information, and then all of the other bad stuff that was told to people wouldn't have never happened. And that's why I keep asking that question over and over again. When we talk about 19,000 people being incarcerated, let's automatically subtract 14,000 from that number. Then the number that we talk about can be more accurate than it would be just to say 50% of this number, because the public don't understand that. Am I making sense?
You are, but may I respond to that?
Yes, ma'am.
First of all, the 71% that I'm using, and like he said, it's not in the report, and that's not been explained before. So first of all, that was not accessible. What was accessible was the 71.5%. I have it in front of me. Y'all see all my tabs, right? This is the 2019 task force report. Those are the only numbers that are available, because it's not like they put out every case and all the factors they consider. The other part, and I know you don't like to hear about 585 because you weren't in the middle of that battle, but the only reason that such a large part of your population right now is not parole eligible is because the prosecutors have gotten on board with not sending the nonviolent people. The sentences are shorter. The use of programs outside are up. And so by the very nature of 585, what we were trying to do is take nonviolent people and get them out of incarceration and put them in those programs, give them less jail time, hopefully so that they wouldn't fall in that recidivism rate. So by its nature, that leaves us with a larger percentage of our population that are now non-parole eligible. And again, all we can go with the numbers that are published. I'm going to add a couple things to my request after today's hearing to try to get those numbers. And I think that the majority of the prosecutors want that information and would be willing to consider it. I think the problem is, for whatever reasons, I don't want to get back down that rabbit hole, there was a lot of miscommunications in different directions and misinformation, and a lot of, I think, assurances of wait till it gets to conference or wait till it gets here, and for whatever reason that didn't pan out. I can't speak to it and we can't fix it. We just, from this point forward, I think being data-driven can help that process.
Thank you again, Ms. Cassie, for coming.
And thank
I
you
look
for the
forward to
opportunity.
working with you to make sure that we get something done by, I think you wanted something done by December or something.
That would be my goal, yes, sir. I think that when we start looking in January and March, everybody's pretty hectic, and right now, it'd be better to get ahead of it.
Thank you.
Thank you.
And to those two speakers that are left, and to all of you all that are left, thank you for staying with us through this, and I think y'all can agree that it has been some good discussion that we've had. A lot of good information has been put out there as well. But we have Mr. Stephen Utroska. Did I get that right? Right. And he's with the state. He's the state director for American for Prosperity. So.
That's right, Chairman. Thank you for having me today. My name is Stephen Utroska. I am the State Director for Americans for Prosperity Mississippi, and I'm going to try to be brief because I know everybody is getting weary of us being here all day. But I want to thank the Chairman for inviting me to come speak and all the members of the body here today. I know all of you took an oath of office because you believe in making Mississippi the best place for us to live, work, and raise a family. So some of you may know about Americans for Prosperity, but I thought I'd give a quick overview. The Mississippi chapter, we're a part of a national Americans for Prosperity organization. We're part of a larger community known as the Stand Together community. Our community works to break barriers that stand in the way of people from realizing their potential. And that includes internal and external factors. Many times those external factors are government intervention. And we work towards moving our society towards one of mutual benefit, where people succeed by helping one another improve their lives. We believe that every person has unique gifts that enable them to realize their American dream. The amazing potential of every individual to contribute to society is why we elevate the voices of our grassroots activists in all 50 states who want to achieve policy reforms to open opportunities for all. AFP created our chapter here in Mississippi 5 years ago, and since then we've been active in influential regulatory reform, education reform, fighting tax increases, working to limit the size of government, and criminal justice reform, among many others. Our dedicated staff here in Mississippi and our passionate grassroots activists come from all different walks of life and many different backgrounds. What unites us all together is our steadfast belief in the power of the individual and individual liberty. We were disappointed to see the veto of these two bills. I know we've talked about 21, 23 more today, but we worked with many coalition partners this year in passing this legislation, and we worked with our activists to encourage the passage through their elected members. This legislation was geared towards safer communities, second chances for those who have already paid their debts to society. They were good pieces of legislation consistent with what our organization and our activists strive for, and that's a smart on crime and soft on taxpayers justice system. While I wasn't involved in legislation in the 90s, I'm fortunate to have senior counsel within our organization that was very much involved with that, and they remember those times. And what the data at that time showed them was that only a small percentage of people committed the majority of crimes in Mississippi. And so many believe that if we could just lock up those individuals, then we could decrease vastly the amount of crime and crime rate we had in our state. So that tough on crime policies seemed like a logical approach at the time, and that really became a mantra to many conservatives. The problem with that approach is the legislation that ensued from that kind of wholesale collected people, and many who wouldn't have previously faced criminal prosecution or extended sentences and kind of lumped them all together with that small fraction of criminals that committed the majority of crimes. And this, of course, caused a drastic increase in the Mississippi populations that we've seen. And so fast forward today, we now have the second highest incarceration rate in the U.S., and 4 of our Mississippi prisons are under investigation by the Department of Justice due to the conditions of confinement. And those two facts are related because our laws require incarceration for many nonviolent crimes and for longer periods than may be necessary to ensure public safety. We've seen in other states similar legislation to 21-23, and they've experienced budget savings and lower crime rates. There's several states been mentioned today. One that we looked at and the data from very much so was Texas. They've been able to avert billions of dollars since 2017 when they put similar legislation in place. It safely reduced the prison populations, closed 10 facilities, and the crime rates are the lowest in Texas they've been since the 1960s. So not only will improvements to and investments in the facilities be necessary to solve the problem with our prisons here in Mississippi, but we must make changes to who we place behind bars, for how long, and what types of incentives we provide for them. So no legislation is perfect, and I'm not here today to try to say that 2123 was perfect, but I certainly think that it was a step in the right direction, and Americans for Prosperity supported that legislation. And I think that legislation like 2123 is what we have to look forward to in the coming session to try to correct some of these issues. So as we move forward, we look forward to working with the legislature, the governor, and other key stakeholders throughout the state to try to change that status quo of our justice system here in Mississippi. So while it's disappointing to see the improvements that we had in 2123 not become law this year, we look forward to productive conversations and meaningful, long-lasting reforms as we enter into the 2123 legislative session. So again, we just came just to show our support of this legislation, show that we worked with many of you in this body to get this legislation passed, and we were glad to see it pass. And unfortunately, it did not get past the governor's desk. But as we move forward, we hope for a new year in 2021. So thank you so much for letting me just come and speak that word of encouragement for this legislation and show that we are supportive moving forward.
Thank you, Mr. Chairman. Stephen, thank you for y'all's support and your conservative record nationally, but not just conservative, but also bipartisan record for trying to address these things. So my question is, and I don't want you to have, I'm not asking you to weigh in to the back and forth, but from where y'all's experience and where you look at 2123, what do you make of the policy from a policy perspective of what you heard Cassie talking about and what you've heard the legislature talking about? Because surely we're not the only state where this has happened. You yourself said that Texas has passed similar legislation that's resulted in public safety or certainly no rise in crime or violent offenses and saved money, and it's gone on. So I think in order for us to get to where we need to go, we're going to have to address this policy difference, if you will. So what do you make of that? And from a perspective of looking nationally and where y'all been, how we can address it?
Sure. Yeah, I can tell you from our perspective, we don't do a whole lot in Mississippi without looking at other states and what they have done from our AFP perspective. So we have active chapters in 35 states, meaning that we have a state director with staff there. Now we work in all 50 states, but we have an active chapter in 35 states, and Texas is one of our largest states. And so that's why we looked at Texas when we looked to support this bill. And any legislation that we support, we have policy analysts back at headquarters and throughout the U.S. that look at legislation before we support anything. And that's when we work with you guys to say, hey.
I guess I'm trying to, and maybe I am putting you a little bit on the spot, and I understand where Cassie's coming from and them, which is, these violent offenders, they've made certain representation, not the violent offenders, but the DAs and law enforcement have made representations to victims and all that. And if we, the legislature, were to change it, that would be going back on that. The legislature, though, is here, and we're, by your own admission, we're second in the country in incarceration after dropping down. We've got geriatric people in there. And rightfully so, the point's been made that the programs for reentry and all are not where they need to be. So I guess I'm asking the point that the DAs and all are making, where has that been in other states?
Yeah, so we've seen the same concerns in other states where we passed similar legislation, and after that has been implemented, many of those concerns have not come to fruition.
So they were unfounded?
I don't know that I'd say that they're unfounded. I think that they come from a position having that perspective of where they're coming from, so I wouldn't say that they're completely unfounded. But in other states where we've seen similar legislation passed, some of their concerns did not come to fruition like they had.
And was 2123, it's not exact, but was it similar to the Fresh Start Act that President Trump signed and that Congress passed in a bipartisan nature?
It was, and that was something that our national organization heavily supported, and we have lobbyists in D.C. that work towards that to help that legislation along in the process. And it has been on from the national down to the state level. This 2123 is very similar in that legislation.
So, in essence, we're not really plowing new ground. We're continuing with the national trend of right-sizing government as it pertains to in the corrections divisions.
That's right. Yeah, and like you said, we are a nonpartisan. We work with anybody to do good as our mantra. We will work with either side, but we have seen in this body and the one across the hall bipartisan support in these bills because we also saw that at the national level, I think.
Thank you very much.
Yep.
Yep. Thank you, Mr. Chairman. Thank you for your presentation, Stephen. Do you know how much money you all put in supporting the Texas legislation?
No, I don't have that number off the top of my head. I can certainly try to get that number to you, though.
Okay, and do you know how much savings Texas have generated since they've passed similar reforms?
Yeah, and again, I don't have the exact number, but in the last, they passed that legislation around 2007, and since then, it's been in the billions.
Billions.
Certainly a larger state than ours and a larger population of incarcerated individuals there, but they have seen a sizable amount of savings.
And you did say billions with a B, not an M.
That's correct.
Okay, and my last question, as far as, if you know, what proposals for violent offenders was in the Texas legislation as far as parole eligibility?
I don't know the exact numbers, but it's very similar to ours because, as I said, we worked with legislators in this body and across the hall to enact these legislations, and that came, a lot of that is from our national group, so I would say that it was probably very similar to what we saw here.
Thank you so much for what American for Prosperity has done across the nation, and thank you so much for supporting the chairman, Wiggins and Barnett, and for supporting 2123. Thank you.
Sir.
Thank you, Stephen. Is there any other questions by this body to Mr. Stephen? Thank you again for coming and sharing with us, and we look forward to working with you all as we move forward in 2020.
Yes, sir. Thank you, Chairman.
Last but not least, Mr. Russell Latino, if he's here. Not here, so I guess that would end our speakers for today, but thank all of you all for coming. I know that it has been a long day, but if you notice, we didn't put an end time on there, and that was for reason because we didn't want to rush through something that's important as this. It's been one of those ongoing things, and we're still not out the woods yet until we can actually get something and signed by the governor to let the rest of this country know that we are serious about correcting our Department of Corrections. And one thing that bothers me is that from some of the reports I've got is that Mississippi is either number 1 or number 2 in incarceration in the United States. And the United States is probably the number 1 incarcerated country in the world. So if the United States is number 1 and we're number 2, and we're number 1 or number 2 in the state, so what did that put us in the world? I think it's time for us as Mississippians to find ourselves not being last, and this is one of those things that I think that we can be first on instead of being last. So thank all of my committee members. And thank all of you all who are here today attended. Thank you for your time, and we look forward to working with each and every one of you going forward to make sure that we do get something good to the governor in 2021. Thank you.